Before the jury even entered the courtroom, attorneys were already fighting over what jurors should be allowed to hear. The defense wanted prior testimony admitted with full context, but the judge drew a hard line on mentioning an earlier acquittal.
The transcribed testimony of the defendant, and then there was another witness who was out of town. Any issues?
I think that's not the case this time around, Judge. I did file a standard motion in limine. The only thing I'd like to add to that motion in limine is any reference to the acquittal or not guilty verdict in the murder trial.
Your Honor, the testimony that
Hold on just a second. You guys are free to go. Thank you.
Thank you, Your Honor.
Your Honor, the testimony that he seeks to introduce is directly from that trial. The jury not only deserves, but is entitled to the context in which that testimony was provided, as well as the outcome.
That's my brother.
I don't know about the outcome. I don't think that is relevant. I think that would be, I don't see how, if it were either way.
It's relevant to motivations for the underlying charge here, Judge. And if the court recalls, we have a motion for speedy trial filed on the aggravated robbery case, which we're going to be seeking to dismiss if we are moving forward on this case, because obviously if the aggravated robbery were tried and he was acquitted, he would be able to make bond on this charge. Whereas if he's acquitted on this charge, he will remain in custody.
So let's take that up at the appropriate time, which will be as soon as this trial's over. So we'll move forward with the unlawful possession of a firearm by a felon. If he, depending on the outcome of that, I would anticipate that something would happen very quickly with regard to that aggravated robbery. If not, I would obviously consider a bond reduction based on all of that. I do think, though, so you still intend, Mr. Coleman, I want to make sure that the testimony that you are intending to introduce from that prior trial, you're still intending to do that, correct?
Yes, ma'am.
Okay.
Carving out any reference to a murder, my plan is to refer to that proceeding as a prior proceeding. I don't know. I'm open to any suggestions from the court how to refer to that.
My position is going to be that we are not getting into going down the rabbit hole of what that was, and for sure not what the final verdict was in that case. I don't see how that would help do anything other than potentially prejudice this jury.
Just for record purposes, regarding that prejudice, Your Honor, the introduction of the testimony from that case by referring to it to a prior proceeding, especially when testimony is being used as an admission of guilt, is in and of itself prejudicial. So I understand your ruling and we will abide by it, Judge, but obviously our assertion is the complete opposite.
Sure.
And we also believe that this case was motivated by the acquittal and intended to show such, Your Honor.
This case being
the unlawful possession of a firearm by a felon, as this case was not filed.
Well, I mean, I'm not going to get into what the state's theory or reasoning to file whatever they filed. They have filed it. It was indicted by a grand jury, set for trial. We're going to trial. We are going to go to trial on that unlawful possession, and immediately at the end, depending on the outcome, bring back up any issues with regard to the older aggravated robbery. We'll get that taken care of at that time. And I'll hear any motions on that. With regard to the notice of intent to introduce the transcribed testimony, we kind of went through that before, I believe, when we were set to go, and then I don't remember exactly what happened, but we didn't go to trial. And my interpretation of 804, I think it's B1B. Anyway, I believe Mr. Coleman is entitled to introduce that. It was from the same criminal episode. So it's not some testimony, sometimes from some other case that has nothing to do with these particular facts. And so for that reason, I am going to allow that testimony, the transcribed testimony. It is only going to be limited, however, to a prior hearing, and not that it was in a murder trial, and not that it was, for sure an acquittal in that murder trial.
And
Mr.
just,
Sullivan.
I am referring to the excerpt, and it's just an excerpt from my questioning of the defendant. It's like it's 6-page excerpt, yes. And I'm happy to give it to the court if you want to review it at afterwards or during a break. But it's just an excerpt of me essentially asking him about the firearm.
Okay,
Your Honor,
yes.
I'm trying to understand why, when a defendant testifies, the state can examine that defendant about their criminal history, but that if a defendant testifies on his own behalf, he can't talk about his criminal history.
If your client chooses to take the stand in this case, then I would think there would be probably different, and that he can say that he was charged with something, but it's not a conviction. And at that time, I think I would want to take that up before that question is asked, and let me kind of think about it and do a little more research on it. Because if somebody's been charged with something, acquitted of it, again, how does that then become relevant or help this jury determine guilt or innocence, is what my thought process is going to be. I'm not going to prejudge that right now, but I am saying right now, before either of you question any witness about the prior trial that ended up in the acquittal, you approach the bench and we discuss it outside the presence of the jury, regardless of any motion in limine. I'm making that order at this time.
I'm sorry, go ahead.
I'm sorry. I would note, Judge, just finally on that matter, that in terms of the state being able to use uncharged offenses that have not, where no guilt has been determined, both in guilt innocence as impeachment evidence, if the jury finds beyond a reasonable doubt that that act actually took place, and the state's ability to introduce testimony on uncharged acts and omissions during punishment, that again, it would re-urge the question that
Again, I'll take it up at that time to see but they're not just allowed to do that without certain findings by the court, certain requirements as to why they are admissible. And so the same, I think, would apply as to the relevancy of it. And we would get to that if in fact he decides to take the stand in this trial. I would have to decide that at that point, but they don't always get to do that, depending on what it is going to show: motive, intent, preparation, identification, and all of those laundry list of things. And it doesn't always have one that applies.
and again, I
Right.
think I'm referencing a defendant's own testimony more so than the enumerated reasons for allowing other extraneous acts into evidence. But those used for impeachment purposes, as far as the witness's credibility. And so,
Well, I mean, but the state's never, not that I know, has the state been able to go into something that for credibility or impeachment for a charge that was either charged and dismissed or charged and acquitted, certain specific instances of some type of behavior maybe could become relevant and admissible. But if it's almost the negative here. There isn't one. It was charged and it's gone. It was acquitted. And so that's, I guess, it's kind of
And I just want to put a point on that, Judge, is with regard to the murder, that's a whole separate offense with separate elements. We are proceeding on a new offense with separate elements Judge, and the potential here is not only to confuse the jury, but also to open the door and allow improper argument. That argument being, because he was acquitted of this, he should be acquitted of, because he was acquitted of that, he should be acquitted of this as well.
Which is the exact same thing when it's the other way around. You can't say he must be guilty of this because he already did that. So we don't allow the state to do that. And so I don't think it's fair to do the opposite of that, if that makes sense.
I think where no, that makes sense. And I think where it'll become relevant is if the defendant takes the stand and there's some sort of use of prior bad acts to impeach his credibility as a witness. And so
well, yeah,
I guess
but
we'll
if those
cross that bridge when
yes,
we come
we
to
will.
it.
But I want to know, so before, if he is going to testify, then we're going to take some time because I'm going to want to know exactly what potential bad acts. It's not going to be the murder. The murder was acquitted. So to me, for all purposes, the murder is outside the scope of whatever is going on here, other than the fact that it's that same, again, criminal episode. He testified, made some potential admissions that I believe and have already made a ruling are admissible in this case, but we're not going to get into the confusing part of the acquittal and use that to potentially try to sway a jury to say he was found not guilty of that by another jury. So this jury should do something in line with that on this case. So
I don't anticipate ever making such an argument, first of all, but I do anticipate introducing testimony from the defendant and as to the fortuity of the alleged possession of a firearm in this case, which again that testimony was provided and tied to an examination of the witness based on the allegations at that time. But again, I understand the court's
okay.
ruling.
All right.
One final thing, if I may, Judge.
Yeah.
Just so we're all on the same page. Are we referring to that prior case, the prior trial, as a prior court proceeding? That's
Yes.
what I'd like to refer to it.
Hearing or court proceeding,
Okay.
either one. I think those could be used interchangeably. If you accidentally say hearing, it's fine. Court proceeding is fine. Trial, not fine. And trial of murder, definitely not fine. So with regard then to the state's motion in limine that has been on file, Mr. Wilkerson, have you had an opportunity to review that?
I have,
Standard.
and
Do you have any
it's pretty
objection?
standard. The only other one that I find objectionable is the one that we pretty much discussed. It's at the bottom of the second page. Additionally, there may be some evidence introduced of another pending charge, but I guess we'll have to deal with that at the same time as well. Because I mean,
I think he's talking about the aggravated robbery.
yes,
Yeah.
yep.
In the guilt innocence, do you anticipate that being an issue at all?
No.
Okay,
No.
so that there's no reason for that to be brought up in the guilt innocence. Now, if the defendant takes the stand, we can take that up outside the presence. It sounds like if the defendant chooses to take the stand, we'll obviously need to kind of regroup with regard to any other witnesses in the guilt innocence. I don't see anything that would make me feel like any talk about the aggravated robbery, definitely that underlying murder case that was acquitted, anything not convicted. It is an unlawful possession of a firearm by a felon. So obviously the fact that he's been convicted of a prior felony is relevant. So we can't get around that with this type of case. So that obviously is jurisdictional and the state will be required to prove up that in the trial for guilt innocence, which is a little bit unusual, but required in this one. Other than that, anything else then? I'm going to grant the state's motion in limine. In addition to what I've kind of ruled on with regard to discussing that prior trial and anything that you think becomes potentially relevant or admissible, approach the bench first. If you think some door's been opened or something like that.
Before we start, I need some instruction on the questioning of the detective. Because one of the questions that I intend to ask is the nature of the investigation. So essentially, you're telling me I can't ask him about the nature of the underlying investigation. How do I talk to him about when this case was finally indicted versus when it was investigated? And then along those lines, why it was investigated?
May I propose that,
At this stage, the court focused less on past allegations and more on legal relevance. The judge repeatedly reminded both sides that this jury was only here to decide one question: firearm possession by a felon. Anything beyond that risked confusing the case.
and of course, the court can make the ruling the court decides to make, but, I mean, certainly he can ask the detective if there was a ongoing criminal investigation. I don't have a problem with that. Whether or not this defendant was subject to a criminal investigation. It's just a reference to the murder and any reference to an acquittal.
So he has no problem. Essentially, this is what I'm hearing. You can say that there was an ongoing criminal
Well-
investigation. You just can't talk about the fact that he was acquitted in that investigation.
Correct.
Yeah, you're the one that's wanting to ask him about the nature of his investigation, and I will concede, I don't see a problem with you asking him whether or not there's an ongoing criminal investigation.
I don't either. But here's the thing, what's not gonna come in is the outcome of that trial. So if you want to question, I think it's fair. I don't disagree, that it's relevant potentially that why they were investigating, and they were investigating a murder. They were investigating an aggravated robbery. But I'm also not going to allow you to go down the path very far of what's the outcome of that and what's happened. We're here on this case. Those cases, just like I would tell any jury, are set for another day, another time, another jury. That's not what we're here for.
Can I talk about the fact that a different defendant was charged with that underlying investigation?
I'll object, Judge.
I just don't think that becomes relevant or helpful for the jury. My ultimate question, obviously, on relevance is how will that help this jury determine if this defendant is guilty of unlawful possession of a firearm by a felon? And so it's going to be very limited on how far I allow you to go down that path, talking about co-defendants and what they were charged with and what's happened on those cases doesn't matter. If it was the murder case and there's a co-defendant to the murder, absolutely, but it's not. That's not what we're here for. It's a very limited requirement as far as the indictment is what it is. Whether he was in possession of a firearm is the question, and muddling it up too much with all the history is not going to help this jury. So I guess that was a long way to answer no. We're not going to talk about the co-defendant and what anybody was charged with. You can talk about that they were
Conducting
an investigation.
But
And in the process of that investigation, I mean, by the time you're questioning him, my guess is the video's already going to be in. They're going to already have seen the video of what happened and in person, and so what we're talking about, just because I've obviously seen it in that trial, is on video. And so the jury will have already seen that. And so going down any other path very far, other than saying either you did or didn't see what you saw, or what was on the video, you interpret the video however you interpret the video, whether or not he possessed a firearm or didn't. There's going to be the testimony that he gave previously. And so I think that limits it.
Mr. Wilkerson also mentioned the timing of how the charges and when the charges were found. I would object to that, Judge, just so long as it's within the statute of limitations. That should have been the subject of some form of a motion to suppress or quash.
No. So the indictment that's going to be read to the jury talks about when the indictment occurred. Obviously, it also talks about
the date of the indictment.
No. In the term assembled.
Right.
I have no objection to that, Judge.
And so I should at minimum have a right to cite the portion of the indictment that talks about when it was indicted versus when it was investigated or committed.
don't necessarily have an
Well-
objection to that, so
No.
much as there an argument that for whatever reason, there's some nefarious, or, malintent on the part of the state judge.
Well, what I don't, because we're not going to get into the murder, and the outcome of that murder. It again does not, I understand where you're going with this. They didn't get a guilty in one, so now they're going to file something else. How's that going to help this jury knowing that?
Knowing that the offense.
How does it help
occur-
them determine if he's guilty or not guilty of this charge? If you're trying to get into, well, they didn't, it didn't work on one, so they're trying something
It
different.
showed whether the prosecution believed that there were grounds for this charge in the first place, Your Honor.
That we routinely exercise prosecutorial discretion in bringing charges, and we make that call all the time, Judge.
And that's,
Well, and that's a call, I guess the issue with that, I don't know that the detective had the ability. He didn't make that call. It was the state that took it to the grand jury, and
We exercised our prosecutorial discretion in this case, like we do in many, many other cases, Judge.
but how does the detective testify to that? I guess is if
all I can elicit from the detective and all I intend to elicit from the detective is the date of the underlying occurrence and when it was indicted.
No objection.
Now, in terms of argument, citing that date, the delay, and the recent indictment of a case, I mean, that's something that
I mean, you can argue the dates, but not argue, we're not going to again get into, well, they didn't get it. You're not gonna be able to bring up, we're not talking about the murder, and the acquittal in the murder. So, knowing that, I guess limit yourself to whatever argument you can make on that. Because I just don't see how that is relevant to helping this jury determine guilt or innocence of this particular offense.
whether or not a grand jury that considered the occurrences in the prior, in this.
We don't know what a grand jury looked at, and we're not able to know. So we don't know what was presented the first time around. We don't know that, I don't think. I mean, we're not gonna have a grand jury here to question, and the detective sure isn't gonna be able to answer that question
Obviously,
from a grand jury.
there had to be an allegation of possession of a firearm in order to.
But that's an assumption.
So,
So yes, I agree that at some point there was, but I don't know. We don't know what the grand jury, why they did what they did, why the state did what they did. And I don't think it's relevant to this jury really to know those things. I don't think it helps them to determine the guilt or innocence of. I mean, you can be unhappy about why it got to this point. I get that. I understand your reasoning and the frustration, but the charge is what the charge is. If it's either guilty or not guilty of this charge, fair or feeling or not fair feeling to you and your client, it's what the grand jury indicted him for. And we're going to limit it to what will help them make that decision in this case.
so can I ask the detective why he thinks it took so long?
That would be pure speculation on the part of that.
I mean, you can ask it if he objects at that point based on whatever evidence has come in. I'm not going to prejudge that. So, I mean, ask the question and then if there's an objection, I'll determine based on what I've heard at that point, whether or not I would rule.
I just don't think it would be speculation for him to answer.
Well, we'll get to that at that point.
Thank you.
All right. So then again, I'm granting that motion. Anything else before we get the jury seated?
From the state judge, as far as time, I can't imagine more than 30 minutes.
Okay.
Concurrent.
Mr. Wilkerson,
Warning.
you're fine with that?
Yes.
What warning to 5 minutes? It makes a difference on whether or not we can do our job if you're here or not. And so we really do appreciate you because we cannot do our job without you. The first thing that I'm going to do, and you can all remain seated while I do this, is I'm going to give you an oath. So I'm going to ask if you would all please raise your right hand. Do you and each of you solemnly swear that you will true answers give to all questions propounded to you concerning your qualifications as a juror? So help you God. Thank you. And so all that means is that you promise to tell us the truth this afternoon. The process that we're going to go through is called voir dire, which just means to speak the truth. And what we will do by the end of today is have a jury selected that will serve for the next few days with us. We don't anticipate the trial this week lasting longer than a few days, and so we just need you to be able to be here for this week. Used to, if you were on a jury panel, excuse me, probably pre-COVID, goodness, pre-COVID, we used to have you go down to that jury paneling room downstairs, and then a judge would come down there and qualify a big, huge group of you, and then you would get sent to the courtrooms. What we have now with iJury, I think, is a whole lot better, because at least you don't have that process that you have to sit through and then get sent to a court. But also what that means is that I need to go through with you what the qualifications are to be a juror. And then I'm going to ask all of you if any of you think that any of those qualifications might apply to you. And if you do think so, we'll have you come up individually and we'll discuss that to see if you are in fact qualified to sit on the jury. So the first qualification is that you have to be 18 years of age or older. You have to live in Jefferson County. And so we need Jefferson County to be your permanent address this week. If you have moved permanently outside of Jefferson County before you came today, we need to know that. If you plan on moving next week, you're good. We just need you to be a permanent citizen this week. You must be of sound mind and good moral character. I'd like to assume that all of you who showed up to do your civic duty probably meet that criteria. You must be able to read and write the English language. If you have served on a jury, so not just this process, but if you were actually on a jury in the last 6 months and the trial that you were sitting on lasted into the second week, let us know that, and you could get a pass this week. If you, again, last 6 months on a jury that went into 2 weeks. You cannot have been convicted of felony of any kind or a theft of any level. You also cannot be under legal accusation or indictment for a felony or a theft of any level. And so that's really it for the qualifications. And so what I'm going to do now is just go kind of row by row and ask by a show of your hands if any of you believe that any of those might affect you. And so I'll start on the front row, coming across this side. Is there anybody on the front row by a show of hands that think one of those qualifications might apply to them? Coming across the front row this way. Second row coming across that way. Second row coming here. Third row.
After ruling on the evidence disputes, the hearing shifted into jury selection. The judge carefully explained fairness, qualifications, and the importance of impartial jurors. With the rules set, the trial was finally ready to move forward.